Call the second case on this morning's docket, case number 115037, State of Kansas v. Jeffrey Redding.
May it please the Court, Michael Whalen on behalf of Mr. Redding, and with Chief Justice's permission, I would request 5 minutes rebuttal.
5 minutes is granted.
Mr. Redding was convicted of Jessica's law crime. He entered a plea agreement. Within the plea agreement, the state and Mr. Redding agreed to a departure motion, to an off-grid sentence, or an on-grid sentence, I apologize. The motion for departure that was filed by counsel, there was language within the motion that stated they were requesting a durational departure. Mr. Redding submitted a written allocution, if you will, in which he was asking the court for as little time as possible because he needed to get back to his job. Following the imposition of sentence, Mr. Redding filed a motion that was entitled a motion to correct an illegal sentence. Within the motion, his complaint was that that the court erred by not considering a second durational departure of his sentence, and that his counsel was ineffective for failing to request an additional departure. The district court invited or requested the Attorney General, who had been handling the case, to file a response to the motion. A short response was filed by the state, ostensibly saying there's no illegal sentence. This was exactly what the plea agreement was. And the court denied the motion. Notice of appeal was filed, and we're before the court today. Again, the main issue that we presented to the Court of Appeals was that the invitation of the state to argue or to make a presentation to the court.
You mean the invitation of the court?
By the invitation of the court, in this case, Your Honor, triggered.
Actually, the court indicated that the move-ant had not served the state, and so it sent the motion to the state as service of the plea.
Yes,
It
sir.
said, I'll await your response.
Yes, sir.
Let me ask you this while you're pausing.
Yes, sir.
If we disagree with you that this motion isn't what the move-ant said it was and argued it was, and instead consider it a 1507, if we disagree with that and say he gets exactly what he asked for, of 223504, then how does that change your argument? Because we have the Duke case that has been affirmed and affirmed and affirmed and affirmed and affirmed, and we don't have any of this language out of 1507 that applies. So how does that change your argument in this case versus the one we just got done?
It makes it very difficult, Your Honor. And I acknowledge that.
And the relief sought was to determine that the sentence could not be upheld because the district judge unlawfully failed to sui sponte consider an additional departure from the grid after they had been presented with a plea agreement that jointly recommended departure from Jessica's Law to the grid.
And argument by defense counsel for the court to follow the plea agreement.
Right. Okay. And there was some kind of brief mention in there that defense counsel didn't ask for the additional 50%. But from that, how can we say that that was an IAC claim that changed the cases cited were motions to correct illegal sentence, all the arguments, everything, all the indicia was that the content of the motion matched its label. And how do we get away with telling a movant they don't get us to consider the motion they actually filed?
By being creative, Your Honor. I mean, quite honestly, because it's not a motion to correct an illegal sentence because there was no illegal sentence. I mean, that's really what it comes down to. This is one where it walks like a duck, quacks like a duck, but it's actually a tiny goose. He is asking for relief that is not about that his sentence was wrong. It's how it was handled and presented by counsel and himself, and then the judge. That's how we get it over to being a 1507 on its face, or the content, because it does not fit in any way as being a motion for a legal sentence, other than that's what he did.
Because the defense counsel had the temerity to push for the joint recommendation of the plea agreement in lieu of consecutive hard 25 sentences that could have been imposed under Jessica's Law.
Yes, Your Honor.
Okay.
I'm not saying that this is the greatest argument. I mean, there are hitches to it.
Well, the main thing I wanted to get to, counsel, is that this isn't the same case as the last one unless we call a motion to correct an illegal sentence a motion under 1507. That's the only way that we get the argument you made the last time. Otherwise, you're back to arguing for us to overturn Duke and its progeny, right? I mean, that's
Yes,
what
Your Honor.
Okay.
Yes. No, I'm not. I don't have an answer for that one. And it does. It hinges on that argument and on the court accepting that.
Can we move then to the to some of the arguments you made in here? Because if we do consider it a 1507, you got the time limit, and you're arguing that that's an affirmative defense on the time limit. But how do we get around 216820C2 that a departure sentence by agreement that's approved by the court is not subject to challenge? In other words, if we do call it a 1507, you've got two procedural hurdles there that kick it out. And if we disagree with you that it's an affirmative defense, because Vontress said that subsection F is the only statement the legislature made about time limits, do you have any other argument for us in that regard?
No, it really does. It hinges on the court finding that there was error by counsel
And so then I want to move to the merits of the illegal sentence. You mentioned that, no, it's not an illegal sentence.
It's not.
Even if we consider it under 1507, what basis is there to impose a duty on the sentencing judge to sui sponte consider a second departure? And that's where you're at, right?
Yes, Your Honor.
What duty is there to do that, and why isn't that contradicted by the statutory provisions that say if a judge is sui sponte going to depart, they have to give notice and do all that, indicating the legislative intent that that is to be a rarity?
It's a very difficult issue to overcome, Your Honor. I mean, the reality is that this was Mr. Redding's desire. And part of it was his belief that by presenting his own argument, and that he, I think, believed that in the manner that counsel presented the language within, or that the language within the departure motion was something that could be used, and that the court, as presented by Mr. Redding, that the court should have considered making the additional. There is not a duty on the court. I will be frank with the court, with this court. There is not that duty on the district court to make such a decision. And I will grant to the state as well that had counsel argued to the court for an additional 50% reduction, it would have been a violation of the plea agreement. The plea agreement could have then been terminated, and he could have wound up serving the full sentence. I don't deny any of that. But we presented the argument based upon analysis of what was presented by Mr. Redding and brought it to this court's attention, doing the best we could to advocate on the arguments we had.
Thank you, counsel.
Thank you, Your Honors.
Morning. May it please the court. The state appears by Stephen Obermeyer, an assistant solicitor general. I will just address, given the concession as far as the terms of the plea agreement, two issues: why it is a motion to correct sentence and not a 1507, and the appointment of counsel issue. With regard to the first issue, I would direct the court's attention to the motion caption, motion to correct an illegal sentence. It's filed within the criminal case, so you don't have to pay civil 1507 filing fees if there are any. The motion to correct sentence can be filed at any time and under 223504, and this is about 2 years after sentencing, I believe, so it would be out of time. The motion that the district court considered said the district court did not consider the proper departure procedure in paragraph 1, and they cite a sentencing appeal case that's unpublished, State versus Brown. And the motion goes on. So really it's complaining about the way that the sentencing was imposed, and it is a motion to correct sentence, and the district court did not have to be creative and consider this as really a 1507 in sheep's clothing of a motion to correct an illegal sentence, because he would have been out of time for that. So the judge sent a letter to the state with a copy of the motion because the defendant did not send a copy to the state, and said, I'll wait to receive the state's response before appointing an attorney. If my recollection is correct, this was an agreed upon plea between the parties. At any rate, in any event, I will await a response from the state in regard to a motion. And then about 9 days later, the state filed a massive, basically 1.5 page response setting out that no hearing is required under State versus Hogue, defines an illegal sentence, and directs the court to the files and records, basically saying that there was no written plea, that there was a written plea agreement, and the sentencing court was not required to sua sponte impose an additional departure. End of state's response. And about 9 days later, the district court issued a memorandum decision denying the motion to correct the illegal sentence. So I think it was properly considered by the Court of Appeals as a motion to correct sentence. It was properly denied without having to appoint counsel to file a response. And I would note on appeals from motions to correct sentence, the standard of review is de novo, since we're considering the same files and records that the district court considered. And so, you know, at that point, certainly there is the assistance of counsel in directing that. And I think the state would be allowed to file a response to a motion to correct an illegal sentence. Don't have to. It's probably best practice to do that. But
in your brief, you define hearing.
yes,
It seems to me, and this put on your hat, that it may be a 1507. And if this were, in some courts have a motion docket, and this came up on a motion docket, the case is called, prosecutor goes to the podium, makes the arguments that you've just said that the assistant AG put in a responsive pleading, and the court then says, well, okay, based on those arguments, I summarily deny. Would you have had a hearing? It seems like from your definition that would be a hearing. And if so, how is that distinguished from reading the responsive pleading and then acting without any rebuttal from this side?
okay. If I understand your question correctly, if the court had called this case and the state was just there and read the contents of the
Some places
response.
have a motion docket.
Okay.
And they'll call the case and kind of see what's gonna get set for hearing and that kind of thing. And says, hey, well, I'll call the case of State versus Reading, case number blah, blah, blah. I see we have a motion here, from
Okay.
defendants filed a motion under 1507.
Okay.
Prosecutor stands up and says, yes, Your Honor, we received a copy of that, and here's why we can dispose of that today. You can summarily deny that under rule so-and-so, whatever, because it's untimely, it's this and it's that,
Right.
and all this other stuff, and some of which would be factual.
Right.
Because we've already said that untimeliness is also includes no manifest injustice, so that it's semi. And the court says, okay, yeah, I see that. Well, I'll use my little minute sheet here and write denied. Would that have been a hearing?
I think yes, that would have been a proceeding that would have required
And
the
what's
appointment of
the
counsel.
functional distinction between that and picking up the response and writing on your minute sheet? based on that response.
Well, but I think you're calling the case with just one party there and asking for their position on that. And I did cite a case dealing with the motion to modify sentence where it was something like that, just the state, no defense, no defendant or attorney, and the court said you have to have counsel on that. So I would think if the court's going to call the case and the state appears, then counsel would have to be appointed.
I have a couple questions on that point.
Okay.
The state has routinely conceded that when there's a hearing in a post-conviction matter, the appointment of counsel is required. The Court of Appeals in this case said when a district court holds a hearing on a post-conviction matter, the defendant has a right to a lawyer present. And really what they're talking about is appointed counsel. Where does that right come from? I'm struggling at that point.
It doesn't come from
I mean, we've already said this morning that the United States Supreme Court has said there is no due process right to appointed counsel.
correct. And on the motion to correct sentence part of it, it's now been amended so it kind of mirrors 60-1507B.
Sure. So there are statutory rights to counsel, but none of them say when there's a hearing you have a right to counsel. To my knowledge, none of them say that. But that's what everyone sort of repeats that language as almost boilerplate of Kansas law, and I'm just questioning whether it's correct.
I think I got that from the Matha Farrick case and the line of cases from that, I guess.
But we're talking about our constitutional law from SCOTUS and our statutes, and Lujan included that in the middle paradigm, the preliminary hearing that you needed counsel. But that case didn't involve appointment of counsel. It's whether the defendant or the move-in had to be present, and so it really wasn't in play there.
Okay.
And that's what I was trying to ask in the last case on the temporal aspect of appointment, whether you can have that initial preliminary hearing. Basically, is Lujan, does it need to be fine-tuned with regard to the middle level? You have the no conclusively not entitled to relief, summary denial. You have evidentiary hearing required because there's substantial issues of law and triable issues of fact. You have to have an evidentiary hearing. Everyone agrees counsel needs to be there. You do too, right?
Right.
And so you have that middle ground of where we're going to take a look at this and all get together and decide whether there are substantial issues of law and triable issues of fact under the statute, under the Chapter 22 statute. And the question is that at that hearing, where the determination is just whether to have a hearing, is whether that triggered the right to counsel at that preliminary hearing. I think that's where we're at.
Yes.
And I think we have the case law out there that you're not really challenging here, but it's kind of difficult for me to see what the foundation of those statements are, that the preliminary hearing requires counsel.
Right. And I did not go as far back to see the first case that cited where you get to counsel. I just know that's kind of the reflex as far as what the practice is on that.
Well, let me ask this. Oh, go ahead.
Is it a concession to the practicalities of if the judge does want a hearing or feels a hearing would be beneficial, your situation is your pro se movement is in a prison that has to be transported, that for practical purposes, having counsel represent them in lieu of that often works much can expedite it if nothing else.
Right. I think if the judge has a question as far as whether or not if it can't be summarily denied, I think the judge is going to appoint counsel number one, to help sort through this lengthy filing and try and clarify the issues.
Can practicality trump the statutory language, though?
Well, it has, but probably it shouldn't, but the other option would be just to summarily deny it and let the appellate courts decide what requires a hearing.
But part of the problem here is this is one of those unusual circumstances. When you're talking about substantial questions of law, you basically have to look at the merits of the motion to determine whether you have a hearing on the merits of the motion, right? I mean, because in order to determine if there's substantial questions of law or tribal issues of fact, you gotta look at the merits and the claims being made, right? And so, to me, that presents a little different scenario than just a procedural matter here that we're dealing with, because it's going to impact how the whole thing plays out from there on, right? I mean, you're dealing with the merits, and if you're dealing with merits, you really ought to be represented, right?
I think that's how that works out. If the judge can't just deny it, you have counsel's appointed, and we proceed from there. I think I would like to just make one comment about KSA 224506 versus the 601507 as far as appointing counsel. I would just point out to the court that is in Article 25 of Chapter 22, which deals with aid to indigent defendants under the Indigent Defense Services Act. So I think that's more a statute about when counsel should be appointed and paid in those types of situations. I think if you have two statutes and one is more specific, like 601507, as to when you appoint counsel, that the more specific statute would control over what I see. This 224506 is just when the Indigent Defense Services people get involved or
I'm sorry, so which are you saying is the more specific?
I'm saying the 601507 statute
Okay.
is the more specific
Thank you.
statute. And also, it's under Chapter 60 as opposed to Chapter 22, which is, it's Code of Criminal Procedure, but I guess it does deal with 601507, so that, disregard that argument.
Well, that's what I was going to say. Under subsection A, it specifically
Right.
has a motion attacking sentence under 601507.
Right.
Yeah.
In this case, it was a motion to correct a legal sentence. It was what it was filed as. The court did not deny the defendant. The court summarily denied it. It was the plea agreement, and I think the Court of Appeals got it right as far as its decision, which I would ask this court to affirm.
Thank you, counsel.
Thank you.
Unless the court has additional questions, I would waive my rebuttal time.
I see none. Thank you, counsel. Thank you both for your arguments this morning on this case. Court will take this matter under advisement.